Hello, I'm attorney Dan Marr from the National New Hampshire law firm of Hamlin Carrigan. I've been practicing in New Hampshire for about 38 years and in Massachusetts for about 28, 29 years. And I practice in both states, and I've represented a number of businesses and owners of businesses. I'm going to be talking today about the importance of having agreements between those owners. If you have a corporation, the agreement between owners is often called a shareholder agreement. Sometimes it's also in the bylaws of the company, but the shareholder agreement is usually the agreement between the shareholders as to how they interact with each other. And in a limited liability company, LLC, it's called a operating agreement, and that's the members' agreement between themselves. You file in the Secretary of State for a corporation just articles of incorporation or articles of organization, depending on which state you're in. And for an LLC, you file what's called a certificate of formation. So the rest of the world looking at Secretary of State's office doesn't know your details, but it's important to have those details between yourselves before you go forward with the business. So you're both very excited about the business. You think nothing will go wrong. But even if both of you right to the very end are great with each other and you get along, something happens in life. Maybe one of you die, one of you get disabled, one of you decide you want to go into a different path of a different career, and the other one wants to stay in that career. Nothing bad faith, everyone acting in good faith, but you want to know what your parameters are. What I talk about in any type of contract is good fences make good neighbors. Well, contracts, knowing what you have for options makes sense ahead of time, so you think about that going forward and planning on your future. So it matters to get one of these shareholder agreement or operating agreements. Shareholder agreements, they don't need to be that complex. Sometimes when you pull them offline, if you have something that you're pulling off and you don't understand what it is, or somebody else provides it to you and you don't understand it, I don't want you to agree to a provision that you don't understand. Either you agree to the provision, or you understand the provision, you like it, or if you don't understand it, you really shouldn't be having the agreement. Some of the more important parts, though, of even a small company business is what happens if one of you wants to leave. And also, if you're working in the company, can the majority shareholder, or if there's three partners and they're all at 1/3 each, can two of you fire the other one from employment? Do you have employment in this situation? Are you a W-2 employee in addition to getting what's called a K-1 for your profits on this? All those things should be discussed ahead of time, and you should figure out whether or not somebody can actually fire you as an employee at will. Because generally, under New Hampshire law, closely held companies, meaning ones that are not traded in the stock market, it's understood that part of your employment is part of your key part of your ownership interest. So if you don't have some type of a clear agreement to the contrary, if you get fired and somebody says, look, you're an employee at will and we're the majority shareholders, we decide to get rid of you, you have a freeze-out claim against the other side. So dealing with that ahead of time makes perfect sense, because sometimes you're just going to disagree with your employment, you may disagree with the share of profits, and you want to address that all in your agreement as to the share of profits. You also want to deal with, and what I've dealt with in any of these operating agreements or shareholder agreements, is what happens if one of you wants to leave and wants to perhaps sell their shares. For one, if you're trying to sell your shares, it's somewhat difficult often to find somebody else that's willing to buy your shares as a minority interest unless the other side agrees. So, but you're putting a provision in there just makes it that much clearer that the other side has to agree to the sale. And maybe it's a matter of somebody is interested in buying, and there's a right of first refusal, where there's a process where you agree to the sale. You might also have an agreement where one of you wants to get out of the company. You do you have a buy-sell agreement where there's a process where maybe we call them sometimes Texas standoffs, where one side can actually say, this is what I'm willing to sell my interest for, and the other side can respond back with, well, no, I'm not going to buy your interest for that, but I'm going to sell my interest to you for that. Maybe that's the formula, maybe it's the opposite of that. There's a lot of things you can deal with regarding appraisals that you deal with. If you do an appraisal, make sure you're dealing with it. You don't just do an appraisal in the beginning and say you're going to do it each year. You have to have a process, because you're not going to do it every year. Life gets in the way, and it's very unlikely that you're going to have the thought process to every year or every 2 years get an appraisal. So have a process upon when one of you wants to sell. What do you do for the sale process, and do you have to pay them over time if you're buying them out, or does that person get their payment right off the bat, or is it paid over time? You want to address those issues. You might also agree in some situations that if you leave the company, you just get your capital investment and that's it. And that's a fine deal, and a lot of companies do that, where they say you're working in the company and that's your major income, and when you're no longer contributing to the company, you get your capital expenses back and that's it. And then you also want to very clearly understand what the process is for somebody removing you in that situation. I've dealt with these agreements both in New Hampshire and in the Commonwealth of Massachusetts. Happy to help you if the opportunity arises. Dan Marr at 603-883-5501. Dan Marr, 603-883-5501. Check out our website, NashvilleLaw, all one word.com. And you can click on my blogs. After my bio, you can click on my blogs and look at a variety of blogs by topic matter. Look forward to working with you if the opportunity arises. Thank you.